Hi, I'm Patrick Barone of the Barone Defense Firm, and I'd like to discuss with you what factors go into making the trial, no trial decision in your Michigan drunk driving case. By the time we get to the trial, no trial decision, we assume that a whole bunch of things have happened. For example, we have complete discovery. We've had an opportunity to review all the police reports, all of the information supporting the reliability of the breath or blood test, any information such as videotapes that we've received from the police officer and from the prosecution, and also we want to take into consideration our own investigation. If we've gone out to the site of the arrest to see what's there and how that compares with what's in the police report, we want to take that into consideration. Obviously, our interview of you, any and all of the information that we have relative to your case, we want to put it all together and sort of evaluate whether or not your case is a good candidate for trial. And we'll give you an opinion as to whether or not we think we can meet with success at trial, or whether or not we don't think we can meet with success at trial. Also, we will have gone through what's called motion practice. If there are any legal issues that need to have been brought before the court prior to trial, then we will have done that. So for example, if we think that there's a problem with the breath or blood test and we think we can keep it out of evidence altogether, we will have filed that motion, which is a legal argument. The judge will have made a ruling, and we will know whether or not the judge has ruled in our favor and whether or not the prosecutor will be able to use the chemical evidence in your case. We may also have contested the validity of the stop or the arrest, and those types of issues can lead to the complete dismissal of your case. Finally, we should have engaged in some type of plea bargaining or plea negotiations with the prosecutor, and we will have advised you as to whether or not an offer has been made and whether or not we think you should accept the offer. Of course, it's always up to you. It's not our decision. But we will tell you why we think you should or should not accept the offer and really what it means, what the consequences will be, how it will affect your driving record, your employment, and so forth. Once we've gone through all of those parts of the case, then we haven't been able to resolve it, then we make the decision as to whether or not we should go to trial. The decision is always going to be yours, not ours. But we will assist you in making that decision by, as I've said, evaluating all of the evidence and discussing with you what your concerns are. In some instances, we've not been able to reach an appropriate plea bargain, not one that's acceptable to you, and you've decided that the only way to get a result that is acceptable is to go to trial. Now, before making that decision, it's important for you to know, for example, what the cost of trial will be. How expensive will it be to take the case to trial? What's the additional expense? Will there be any expenses other than that you pay the lawyer? For example, are there expert witness fees? And so forth. That will all be discussed. Another thing that clients are always very interested in knowing is if they go to trial and lose, will they get a worse punishment than if they pled guilty? In most instances that's not true, but it's important for us to discuss that with you and, if it's appropriate, with the judge so that you can make a fully advised decision. Once we've gone through all of those stages, given you all of that information, then it will be up to you to decide whether or not to take your case to trial.